Good afternoon, everybody. My name is Todd Culkin. I'm a solo practitioner here in the city of New York, and I act as corporate counsel for small to medium-sized businesses. My specialty is socially conscious entrepreneurship, also known as socially conscious entrepreneurship. And if you would like to know more about what that is and how it works and how it can benefit your practice, then stay tuned in another hour. We're doing another one of these specifically about socially conscious entrepreneurship. But what I'm here to talk about right now is the Benefit Corporation, which is a brand new style of legal entity specifically tailored for socially conscious entrepreneurs and essentially people who try to make money by doing the right thing. You know, in today's corporate culture, a lot of people, especially top talent coming from the top schools, are being subtly reminded, especially by the economy, that we spend the vast majority of our waking hours working. And many people, myself included, believe that you should be spending that time doing something that you're proud of. And so the Benefit Corporation allows companies who really have an eye toward doing the right thing as opposed to only profit. It allows them to insulate themselves from liability with respect to their fiduciary duties. Now, this is different from a non-for-profit, and we'll go into that in a little bit as to the difference between a benefit corporation and a non-for-profit, because they're very different. In fact, depending on what your client tells you, you may want to steer them towards the non-for-profit, or you might want to go towards the benefit corporation. That said, let's get started, shall we? So, the questions that I'm going to answer today, the questions that I'm going to answer in the slides today, please ask questions, interrupt me. To me, it's really important that we have a dialogue between viewers and presenter, so feel free to ask questions, and I'll be happy to answer them. Okay, first is, what is a benefit corporation, also known as a B Corp? Now, I'll say right now, as a almost disclaimer, that the term B Corp is actually a registered trademark of B Lab, or Benefit Lab. It's a non-for-profit. We'll talk about that in a little bit, but I use the terms interchangeably simply for convenience. However, when push comes to shove, a benefit corporation is a legal entity, whereas a B Corp is a designation given to certain benefit corporations by B Lab. Again, we'll get into that later. However, it's always important to put things on the table when they need to be. So, the second question, when do I advise my client to be a B Corp? When is it necessary? When is it unnecessary? These are things, there are many different situations, and I'll help counsel you through. Third, what is B Corp certification, and is it necessary? You may have heard of B Corp certification or third-party standard. It depends on what state you're in as to whether it's necessary or not. However, again, we'll get to it. Next, how does a company become a B Corp or benefit corporation? And finally, what are the benefits and drawbacks to the B Corp? Now, and I work with a lot of startups, right? People who are coming to me and say, I have an idea for a business. And whenever I'm counseling them as to the different entity types, just like every other corporate attorney should do, you have to weigh the benefits and drawbacks of each entity type. Now, the B Corporation or benefit corporation has only been around for a few years, all right? And I mean, let's see, the first state to enact it was Vermont in 2010. So this is very new. Not a lot of attorneys know about it. However, it's a really great tool for attorneys to use to help socially conscious entrepreneurs. So why don't we get into it? So what is a B Corp? It's an incorporated entity with a legal obligation to serve the public benefit. Now, you may ask yourself, what is the public benefit? Well, each state has a different definition of public benefit. And I am going to, since we need some kind of chapter and verse on these things, I'm going to read from the New York statute. Keeping in mind that as an attorney here in the state of New York, this is the statute that I work from when counseling my clients, unless they're coming from another state. But it's a really good template. In fact, the Article 17 of the Business Corporations Law was enacted by Governor Cuomo just last year. So it's new, it's somewhat exciting. But this is how the state of New York defines public benefit. There are actually two ways. There's the general public benefit, which is a material positive impact on society and the environment, taken as a whole, assessed against a third-party standard from the business and operations of a benefit corporation. Now, as someone once said, that's just vague enough to work, right? So let's just take a look at it piece by piece. A material positive impact, all right, that means that you have to actually do something positive, right, on society and the environment, okay? So it's not just helping poor children in Africa, it's also helping poor children in Africa and making sure that their water is clean, okay? Now remember, this is general public benefit. There's specific public benefit which gives more room for other types of benefit corporations. Also taken as a whole and assessed against a third-party standard. So why do we have that there? Well, there are a lot of different opinions out there, let's call it. Some people who believe that society would have a material positive impact if, say, a certain type of person weren't around anymore, right? So you can say, as a Jew, the Ku Klux Klan thinks that people like me, other Jewish people, weren't around, that would have a material positive benefit on society. A vast majority of people wouldn't agree with that, I'd hope, and so that's why we have the third-party standard out there. Now, third-party standard means, with respect to benefit corporations, there are a slew of organizations out there that all they do all day long is evaluate benefit corporations. B-Lab happens to be the largest. However, there are over 100 out there. And what they do is they score benefit corporations based on transparency, accountability, and social impact. Also environmental impact, if that's as the case may be. So when you have the third-party standard, and granted there is a lot of wiggle room within it, you're still able to allow for more people to incorporate as a benefit corporation and help society, whereas you have fewer Ku Klux Klan style groups coming in and taking advantage of the liability protection, even though they're not helping society at all. Okay? So you have a general public benefit, right, which I just described here. Now, every B corporation must, in their articles of incorporation or adopted in their articles of incorporation through board action, have the general public benefit as part of the goals of the corporation. Now, the trick behind a B Corp, to the extent that there's a trick, is that investors, shareholders, and the public understand that when you're dealing with a B Corp, you're dealing with a company that doesn't only have profit as its goal. So with a normal corporation, a C or an S Corp, you have the pursuit of profit, and that is the only real goal. That's the fiduciary duty. All right? With a benefit corporation, you have two. You have the duty to create profit, and also the duty to help people, to help with the general public benefit and or a specific public benefit. So when you have shareholders in your company, and the benefit corporation is designed so that it has a general public benefit as well as a particular specific benefit, which we'll get into in a little bit. It has a transparency. Not only does it attract investors, but also, since those investors have been told in advance that the corporation isn't only there for profit, then the directors and officers of that corporation are protected from derivation lawsuits and shareholder lawsuits as long as they're working towards that public benefit. Again, we'll get into that in a little more detail. Again, if you have any questions, feel free to put them on. So, B Corps are obligated by law to help the community, okay, as well as for profit. What does that mean? Now, in some states, including the state of New York, it's not so much that the benefit corporation can help others, it must. Okay, so when you have a benefit corporation, when you're dealing with an entrepreneur that says, ooh, B Corp sounds good, you need to counsel them, because it's a separate standard that they're putting on themselves. Now, for people who are trying to do the right thing and people who are, they're true to it and they're genuine, absolutely, the benefit corporation is great for them. However, if you're looking at someone who just wants the B Corp in name only and that's it, it's not going to fly, because any of their investors can come in and say, look, you told us that the company was for the public benefit, but in fact you're not doing that at all. And so in some states, New York included, the lack of going through the public benefit is an actionable offense. In states like Illinois, that particular cause of action is banned. However, in the state of New York, by virtue of the statute, it's still a potential cause of action against the directors and officers. So you have to be really careful. And finally, sorry, I have to go back. A B Corp may designate a particular public benefit purpose, okay? And I'm just going to use the New York statute. Is a specific public benefit includes, right, but is not limited to, providing low-income or underserved individuals or communities with beneficial products or services, right, helping poor children in Africa, promoting economic opportunity for individuals or committees beyond the creation of jobs in the normal course of business. Let's say you want to have an incubator that helps inner city high school grads get jobs or to start their own businesses. B Corp would be right under that. Third, preserving the environment. Okay, that's pretty obvious. Fourth, improving human health. All right, this is where you have a company, say a pharmaceutical company, that they don't want to do all they want to do is the cancer-saving drugs, not the, for lack of a better term, the cosmetic medications, those which, yes, they help people, but they're not really helping the public and they're really more for profit. Those out there probably can think of a few examples, one involving the color blue. Promoting the arts, sciences, or advancement of knowledge. And this is great. So a university could theoretically be a B Corp, although it makes more sense for them to be a 501c3. Finally, increasing the flow of capital to entities with a public benefit purpose. This is where the venture capitalists come into play. A venture capital firm can incorporate as a benefit corporation if they want to have the vast majority of their portfolio go towards either eco-friendly or socially conscious companies. Also, there are index funds that do similar things. Now, there's also the accomplishment of any other particular benefit for society or the environment. That's the catch-all. All right, I've personally used that catch-all to bring in to have my clients incorporate as benefit corporations where it didn't fit the other things. However, this client was genuine. She wanted to do the right thing, make money while doing the right thing, and the B Corp seemed appropriate. Now, finally here, a benefit corporation is not a 501c3 organization. This is where people get mixed up. A B Corp essentially is a hybrid between a non-for-profit and a for-profit corporation. What I mean by that is it has the duties that a 501c3 has just to do good without all the regulations. At the same time, it has some of the freedom that's allowed for a for-profit organization. Just a couple of examples. Number one, 501c3 organizations, as the non-for-profit attorneys can tell you, all the employees have to be reasonably compensated. They're reasonably compensated for what exactly? When you look at the job description, you look at what other non-for-profits are paying their people. Now, with a for-profit corporation, with a few notable exceptions that are securities broker-dealers, there's no restriction. So you incorporate as a benefit corporation, you're able to do the right thing, be protected from liability in doing the right thing, and you can pay yourself whatever you want. You can pay your employees whatever you want. Another thing, 501c3 organizations, they have to be very careful about gaining corporate sponsorships. And again, the non-for-profit attorneys can tell you, I happen to work with non-for-profits as well, but there's something called a qualified sponsorship payment. Right? You have to be, non-for-profits need to be very careful about how they receive money from corporations and what they dole out as compensation for the donation. A benefit corporation has no such restriction. So Let's say a benefit corporation wanted to throw an event to raise money for a particular cause. And they take on corporate sponsors, all right? It seems like a great way to make money for the cause. Now, if this company were a 501c3, they had to be very careful about whether it's a qualified sponsorship payment. However, as a benefit corporation, there's absolutely no restriction. So they can take pretty much as they want, right? The company, the sponsor doesn't take it as a deduction for charity, takes it as a business deduction, and the world continues going round. Okay, so again, benefit corporation, the takeaway from this, benefit corporation is a hybrid between the 501c3 and the for-profit entity. Keep in mind, there's no tax difference, at least right now, between a benefit corporation and a regular for-profit corporation. They can file as an S or as a C. There's no difference. It's just like a regular corporation. Keep in mind, there's no 501c3 status, so they still have to pay taxes, which is fine because they are going to make profit. That's the point. Well, one of the points, at any rate. Okay. So, who are B Corps? There are a bunch of famous ones out there. The ones that I like to think of are Ben & Jerry's, which has been a pioneer in socially responsible entrepreneurship for the last 20 years. They became one of the first benefit corporations in the state of Vermont. Now, King Arthur Flour, which is owned by the workers, which is an interesting little twist. It's a worker-owned company and also a benefit corporation. So each and every one of the workers is a shareholder in the corporation. So the corporation has the fiduciary responsibilities to its workers as shareholders, which is an interesting sort of thing. And also Patagonia, the maker of high-end outdoors gear, they were the first benefit corporation in the state of California. That's why I bring it up. Other benefit corporations that are out there, Cabot Creamery. Let's see, Clean Tech Law Partners, actually a law firm that all they do all day long is bring cases to help the environment. They're a benefit corporation. There are, Comet Skateboards, a company that makes environmentally friendly skateboards. So really, it goes all over the place. If you go look up benefit corporations on the internet, you will find them in all different industries, from food, as we were showing before with Ben & Jerry's and King Arthur, to skateboards, clean electricity, venture capital, and everywhere in between. So really, because of this specific public benefit that I was telling you about before, the accomplishment of any particular benefit for society, it allows any company that wants to do the right thing and wants to make money in so doing to avail itself to be a benefit corporation. Okay. Next, I'm going to go through the benefit corporation states, because one of the first things you have to ask yourself when you're starting a new business is, where am I going to incorporate? Right? Now, if you're looking to be a benefit corporation, right now, there are only a handful of states that allow it. California, here the great state of New York, Hawaii, Massachusetts, Pennsylvania, Virginia, Illinois, Maryland, New Jersey, Louisiana, South Carolina, and the great state of Vermont. Now, corporate attorneys who are out there probably noticed that there were two very important corporate, should I say, shelters missing: Delaware and Nevada. Now, there are a bunch of other states that have legislation pending for benefit corporations. However, Delaware and Nevada are not either of them. They're not even pending in their legislatures. So if you're going to instruct your client about where to incorporate, and you want to avail yourself of Delaware, you can't also be a B Corp. And I'll be honest with you, I don't think that's going to happen for a long time, especially since Delaware has been it's been groundbreaking with respect to the fiduciary duty to shareholders. And a benefit corporation, I don't think that's going to fly with that legislature or those judges. On the other hand, Nevada, which people now think of as the wild, wild west of incorporation, because Essentially, Nevada doesn't disclose anything to people asking for it. With respect to its corporations, Nevada also isn't even entertaining the idea of a benefit corporation. And there are some good reasons for that. One, and honestly the biggest one, is with benefit corporations, there's a lot of transparency and there's a lot of disclosures. So it's not really cogent for, or rather prudent for Nevada to continue going the way it's going and have the benefit corporation at the same time. Now, I mentioned these different states also to tell you that when you're telling your client about benefit corporations, check your state. I cannot emphasize this enough. The rules for benefit corporations are different in every single state. Okay, let me give you one quick example. In the state of New York, right, you can have all your board members just be board members as a benefit corporation. However, in the state of Massachusetts and also the state of Illinois, you need to designate a benefit director. Okay, now a benefit director is, as it's defined in the statutes, a director elected separately from the rest of the board that's there specifically to enforce the public benefit of the corporation. All right, so if you're working with a two-person or three-person company, you're looking at Illinois, you're looking at Massachusetts, keep in mind you're going to have that separate board member. Also, as I stated before, in the state of Illinois, it's not actionable when the directors and officers do not fulfill the public benefit. All right, so let's say for a moment that we have a benefit corporation here in the state of New York. And for the first couple of years, they have their investors, they sold their stock. For the first couple of years, they haven't really done anything in the public benefit. They haven't done any charity fundraisers. They're really just focusing on R&D on a product, right? And they think that product is going to help the environment and help the community. Now, shareholders might be annoyed at this, right? Because they invested in a company that says in their articles of incorporation, we are here for the public benefit as well as profit. Meanwhile, in the state of Illinois, if a shareholder tried to bring an action saying you have failed directors and officers of the corporation to fulfill the public benefit and therefore I must bring this action on behalf of the shareholders, that wouldn't fly in Illinois. However, in the state of New York, it still might. So you need to be very careful. Another aspect of the B Corp that's different in every state is the concept of the third-party report. Okay, so in almost all of the states, actually, it's a bunch of them, there are only a couple of exceptions. The benefit corporation must every year or every 2 years, depending on where you are, submit to a third party its books, its activities, for its rating. So remember earlier I was telling you about B Lab and those 100 or so companies that all they do all day long is rate benefit corporations. This is where they come into play. And so every year, every couple of years, you need to submit all of your paperwork to those organizations so that they can do the rating. Now, there's no confidentiality there, keep in mind. But at the same time, it's not a matter of public record like SEC disclosures are. So it's a balance when you're talking to your clients about their activities, and when they go every year, every couple of years to do their third-party standard review, you need to watch out what the third-party standard provider is doing with the information, right? And the reason why I bring that up is a lot of times these benefit corporations, especially the ones that want to help the environment, are based upon a piece of intellectual property. Usually it's proprietary in nature, right? So we have, just example from earlier in the talk, Comet skateboards, right? Now, Comet Skateboards makes eco-friendly skateboards. Now, I have no idea if Comet Skateboards uses a type of plastic that's eco-friendly, or maybe they've invented a whole new process. I don't know. However, if I were their attorney, I would say that you want to make sure that if it's a trade secret, that they have to make sure that the third-party standard advisor is bound by a non-disclosure agreement not to let the cat out of the bag. All right. Also, if the thing is patentable, well, same idea. You have a piece of proprietary intellectual property that really is the core of a company on the one hand, and on the other hand, you have a legal obligation to give all of the information about your company to a third party for review. So again, keep in mind, this is not completely insurmountable by any means. You can very simply just put in a non-disclosure and watch them like hawks. It's just something to think about. Okay, so there are two major ways to become a benefit corporation. And again, I tell you, always, always, always check your state, right? However, pretty much all of them have two ways to do it. Number one, incorporating as a benefit corporation. Now, how is that done? Well, in the state of New York and almost every other state that does benefit corporations, you have to have certain language in your articles of incorporation. And that language is very simple. This corporation is created in the general public benefit pursuant to named statute here. So in this case of state of New York, it would be Article 17 of the Business Corporations Law. That's it. You're a benefit corporation, at least under the laws of that state. Another way to do it, if you've already, say, if the company's already been around for a while, there's a new board of directors, and they want to switch gears, right? And they have the company was going one way, and now they want to be all about socially conscious entrepreneurship. So they say we want to become a B Corp. It's actually also sort of simple. What we have to do is declare benefit corporation status by board action. Now, since that is an action of the board to change the articles of incorporation, it requires a 2/3 vote. Okay, so make sure that when your client is getting ready to become a benefit corporation, that they do it the right way. You have to have 2/3. You have to have 2/3 there. Make sure you do your proxies correctly. A lot of companies where a board action didn't go through, or rather, it wasn't valid in litigation. It was thrown out by a judge because there wasn't quorum at the meeting, or the action required 2/3 of the vote, and they didn't get 2/3 of the vote. You have to be careful for our clients. We don't assume the worst will happen, but we prepare in case the worst happens. And so you're going to have them incorporated as a benefit corporation. Keep in mind that you have that language in your articles of incorporation. So if you want to leave benefit corporation status, and it's not that hard to do so, you need to have another vote of the board. Okay, so whether you've incorporated from the outset, or if you've declared B Corp status by board action later in the life of the company, you still need to have a 2/3 vote in order to get rid of benefit corporation status. And then after you do that, you have to make sure that all your investors know that that's exactly what has happened. Now, in the state of New York and a few of the other states rather, you have to have the name benefit corporation, or rather the verbiage about the company being a benefit corporation, on all the stock certificates. All right. Again, this is all about transparency, so that the investors know that when you're investing in XYZ Corporation, you're investing in a company that has two goals: to make profit and to help the community. Okay. So if you're getting rid of B Corp status, you need to recall all the certificates, change them, take off that verbiage, and return them. Now, some investors might say, if you're doing that, I'm selling my shares, and that's absolutely fine. You deal with it as it comes. Okay, fiduciary duties. The whole point of a benefit corporation, which was created by B Lab, which essentially was a think tank for socially conscious entrepreneurs a couple of years ago, was to allow companies to work in the public benefit without worrying about derivative actions. Now, what do I mean by that? For all corporations that exist right now, all the for-profit corporations that exist right now, directors and officers have two duties, right? You have the duty to loyalty, you have the fiduciary duty. Now, the fiduciary duty is, especially after the Revlon decision in Delaware, it's always highest bidder or most profit. What is the reasonable business decision that would bring on the most profit for the shareholders? All right. Benefit Corporation takes that duty and splits it in two. So not only do you have the responsibility towards your shareholders for profit, however, also you have the fiduciary duty to do the right thing and to fulfill the public benefit. Now, if you've only designated a general public benefit, then it's sort of wishy-washy, right? It could be anything that helps the environment or helps the community. If, however, you did a specific benefit purpose, which can be helpful for gaining investors, right? Investors really don't, they want to know that their money is going towards something concrete. And so doing a specific public benefit purpose is a really great way of showing the investors this is what we want to do, right? But at the same time, you're going to be held to that standard. Now, the way it plays out, and there's not a lot of case law about this because this entity is brand new, right? There has not been any derivation actions so far, and thank God for it. But the statutes are somewhat clear. However, of course, the judges are always going to give interpretations. In fact, in a year, I might do an update of this for a case law that comes through, because right now there's literally no precedent on the subject. However, the way it's currently working in the statutes and the way they're structured is if the directors and officers of a corporation do something that does not give any profit to the shareholders but fills the public benefit, they have a defense. In fact, it's an affirmative defense. So, I'll give you an example. I have a client who helps divorced people. All right, and I've incorporated her as a benefit corporation. Now, she's slowly but surely getting investors, and the reason why we thought the benefit corporation was important for her was that she also wanted to help battered women, okay, which sort of goes hand in hand with divorce. So let's say a few years from now, her company has some money. She decides to open a center for battered women out in Riverhead, Long Island, right? Shareholder comes back and says, that's not making us any money at all. It's not helping us in any way. You're taking my investment dollars, you're throwing them down the toilet. I'm going to bring an action against you, the directors, right, on behalf of the company, right, because that's how the derivation action works, to either A, to stop you, or B, to get damages. Right? Now, if this should happen, my client can come back and say, no, this is a benefit corporation, specifically incorporated to do two things, right? Because you can have multiple specific public benefit purposes. One, to help people going through divorce in their families and to improve their quality of life. And two, to help battered women survive their plight. That's a defense. That's it. So, and you could probably get out on summary judgment if it's clear enough that it serves the public benefit purpose. So litigators, and this is not just for the corporate lawyers, this is for litigators too, because as you know, every lawyer knows, litigation is everywhere. It's expensive, it's ugly, and if you have a tool in your tool belt that can help your client continue forward almost unscathed, you should use it, right? So this is part of the planning for a new company. And he comes to me, let's just say an entrepreneur comes to me and says, you know, like my client, I want to help divorced people, I want to help battered women, right? But I want to be able to make money doing it. Fine, benefit corporation, right? We put in their bylaws specifically what they're looking to do and how they're looking to fulfill the specific public benefit purposes. So that down the line, when she has investors, let's say one of those investors just didn't think that, you know, opening a center for battered women was a good business decision, and that comes up, we're ready. All right? Now, this is a double-edged sword. So remember, in the state of New York, you are able to bring an action for failure to go into the public benefit, so it's kind of a double-edged sword. Also, I should note that in every single statute that creates a benefit corporation in all the states, it has the following clause, which is really important. It says that third-party beneficiaries to public benefit are not considered shareholders. In other words, the directors and officers do not have a duty towards a third-party beneficiary. Now, this goes all the way back to contract law, basic contract law, about there being no such thing as a third-party beneficiary unless they're named as such in a contract. So the same idea same idea is at play here, where you have someone who benefits from the company, but they're not an investor, and say they're being hurt by something. Let's use the divorce example for a moment. Let's say that the company has taken a bad turn and they have to close the battered women's center, sadly. Okay. Now, the patients, the women there who were being taken care of by the battered women's center, they're obviously hurt by it. They've obviously been damaged in some way. They're no longer able to take care. And so they could theoretically bring an action saying, hey, we are third-party beneficiaries to your public benefit. You've taken it away from us. We deserve damages. No state allows that, and no state should, right? At the end of the day, the only fiduciary duty that you have as a director or officer is to your shareholders. That's it. Doesn't matter whether you're a for-profit corporation or a benefit corporation. Is what it is. So as I said before, so this works in conjunction with their normal duties to the shareholders. Again, profit and public benefit together. If you're serving profit but not serving the public benefit necessarily, you can choose one or the other, depending on what you're doing. Now, if someone brings an action to you and says that, oh, this business decision didn't bring profit, but it also didn't help for the public benefit, well, now you have a real case on your hands. So, generally, when you're dealing with a derivative action, you got to choose between the two fiduciary duties. And only people who are absolutely serious about achieving the public benefit should be incorporating as benefit corporations. For that reason, it truly is a double-edged sword. Okay, so why become a B Corp, right? So the first, as I said before, is liability protection. It allows you as directors and officers to do the right thing and to help others and not worry about shareholders coming back with you and saying, oh, but that doesn't give us profit. You're protected, right? That's really great for socially responsible entrepreneurs to have that off their back. So they can freely ask for investment and take the money knowing full well that investors are coming in with two goals in mind. Yeah, I'd like to make some profit off of my investment, but also my money is going towards the public good. And second thing, investment opportunities. There is a whole sector out there of investors who are looking to make the world better through investment. In fact, that's why there are all these venture capitalists who are incorporating as benefit corporations. They just want to invest in companies that help the world get better. It's fantastic. So if you make yourself a benefit corporation and you're looking for investors, and investors come to you and say, I'm really looking for a company that does good. They say, well, we're for you. Now, on the other hand, and this is where it's a double-edged sword again, as a benefit corporation, you need to disclose that as such to all of your investors, of course. So investors who really aren't in the mood to have their money help others, they're probably going to be turned off by this. You know what? And that's why only certain people should incorporate as B Corps. It's not for everybody, but for those that are really serious about it, it is a fantastic tool. Also, stronger employee morale. I hinted at this at the beginning of the talk. Top talent, people are going from the top schools, and they work really hard and they're really smart. They want to know that their work means something. They want to know that they're working for people who are doing the right thing, and it's a company that they can be proud to work with. Now, you can argue that with the economy being the way it is, a job's a job. However, it's not always going to be that way. In fact, I personally am starting to see it change with my client base. More people are coming in saying, I want to start a business. And it's not because I don't have a job, it's because they want to do things the right way and create something. So it's worth a thought. If you're able as a company to recruit top talent, you're going to get a better quality product, which means you're going to become more profitable. And also, as a benefit corporation, you can do more good because you have more money to do good with. All right? The fourth thing is making doing the right thing your business model. All right? That's really attractive for some, not attractive to others. But it's really, if it's who you are as an entrepreneur, and that's what you want to do, then you should be protected. Right? You have full transparency for investors to understand exactly where you're coming from and what you're trying to do. You know, doing the right thing, your business model gives your life meaning. It gives your business meaning. And also, you do good without the 501c3 restrictions. That's what I was talking about before. I have someone came to me the other day and said, I want to open a non-for-profit. I said, okay, great. Well, tell me what you do. He says, well, I am a chocolate maker. Okay, great. Well, what kind of non-for-profit do you want to start? She goes, well, I'd like to do what I'm doing now, but make it a non-for-profit. So this is sort of a classic problem where you have somebody, they want to do the right thing and they want to make good. At the same time, it would probably kill them financially to go non-for-profit because of all the regulations. And so I said to this person, well, let me ask you this, is this your only source of revenue? She says, yes, this business is my primary source of revenue. So because of all the restrictions about, also don't forget the unrelated business income tax. And if you're not familiar with it, I'm sure Law Online has lots of lectures about that. You have the qualified sponsorship payment, you have the reasonable compensation standard. A lot of reasons why going non-for-profit might not be the best way to go, simply because you need to make a living doing this thing. So Benefit Corporation allows you to be protected from liability and at the same time do good and not have to worry about the 501c3 restrictions. It's pretty excellent. Okay, let's go to B Corp certification for a moment. What is B Corp certification? Now, as I've mentioned throughout this presentation, there is a non-for-profit out there. Yes, it's a non-for-profit, not a B Corp, called B Lab. Okay? And B Lab was created a few years ago specifically to come up with a way for socially conscious entrepreneurs to be able to do what they do, right? What we've been talking about from minute one here. And they came up with the concept of the B Corp, also the BLLC, which is currently not available in the state of New York. In fact, it's barely available at all. Essentially, the idea is to act like an LLC, but have the liability protection from investors and other members. The thing is about the LLC is there are other ways to gain that protection and still be an LLC if you're savvy enough with the membership agreement. But also, and this is coming from the B Lab people as far as why they want it to be a corporation, not the LLC, is because investors generally want shares of a company, right? So that's why the corporation made more sense. But anyway, I'm getting ahead of myself. B Corp certification essentially is the third-party standard as done by B Lab. Okay? Again, B Lab is the largest out there of that slew of about 100 companies that do the third-party audits every year of benefit corporations. So B Lab, what you need to do is you submit your corporate documentation with them. You submit your financials, your business plan, and you also have to sign their you also have to sign the B Lab Declaration of Benefit Corporation, right, which says we will do this, we will do that, we will do the other thing. It's really interesting. You should check if you're interested in benefit corporations as far as the way B Lab does it. And there's also a lot of great information about their legislative efforts in trying to get benefit corporations allowed all over the country. You can go to benefitcorp.net and check it out. Is B Corp certification necessary? No, absolutely not. Does it help? Does it help you get investors? Does it help you gain more notoriety as a benefit corporation? Honestly, who's to say? They are No, they're large, they're strong, they're a little over 300 members, including, but not limited to, Ben & Jerry's, and Patagonia, and all those big companies that are benefit corporations. But there are over 100 other companies that also do the third-party certification. So you don't have to go with B-Lab if you don't want to. You can go to another one if you have, if you don't like the way that B-Lab does it, and they have a very specific scoring based on different factors like transparency and help to the environment and this and that, and they give you a score out of 200, and if you're over 80, then you're certified. If maybe the way you do things is not the way that B-Lab does things, then well, maybe it's a good idea to go look at another one. And there's absolutely nothing wrong with that. However, I would say that you have to remember, again, with checking your state, the certification by a third party, in some cases needs to be, well, in all cases need to be made public to all shareholders, right? So in all the states, you need to every year or every other year, depending on who you are, go to your shareholders and give them the report. Say, here's how we, here's the third party standard, these people saying how we helped the general public benefit this year, this is how we did the specific public benefit, here's our score, thank you so much. In the state of New York and a few other states, you need to publish it on the internet. Okay, you have to have the report on your website at all times. Okay, now this is where it gets kind of iffy with respect to what information that third-party standard company has, right? Or what's in the report. This is not a matter of public record. At the same time, you're being told to disclose something all the time to the general public, and what's more public than the internet? So attorneys, make sure that your clients are well aware of what the value driving aspect of the business is. Okay, so if it's intellectual property based, you go to a third party certification corporation that will not disclose how it is that your client does what they do. Okay, because that's going to kill the company. Right? If it's something else, if it's like a trademark that makes it really strong, you don't really have to worry, especially if you've already registered the trademark. If it's a particular algorithm or something similar to that, also you just make sure that's not being disclosed. If you have to deal with, if you're in a scenario where you have to deal with a particular company for third-party certification, maybe you have an investor or a bunch of investors who only trust this one company, then make sure you have a non-disclosure. Really, really important. Have the non-disclosure in place with the other company to the extent that you can, and if they won't sign it, and the investors say, look, we need to use this company, you have the client politely come to them and say, look, what we have here is a trade secret. All right, something that if we let the cat out of the bag, we lose our market edge, and that's going to kill profit at every aspect of the company. It's not in your best interest, investor, as well as my best interest, to disclose all of this to the third party company. Hopefully, the investors will understand. But these are things you have to keep in mind. All right? Okay, signs of a B Corp client. This is my favorite part, right? Now, as a business attorney, I like to work on one-on-one with my clients, and I like to educate them. And so it's always fun for me to hear the hopes and dreams of my clients and really figure out what works best for them, okay? So here are some signs of a client, if they come in, they're talking to you and they're giving you certain signs that they might be ready to be a B Corp, okay? Number one, I want to help people and make money, right? That's the two elements, right? You have helping people, the public benefit, and also making money, profit. 1, 2, you got it, right? Second, how do I turn my business into a non-for-profit? The chocolate company I was telling you about before, they say, oh, how do I turn my business, my money-making enterprise, into a non-for-profit? You look at that, and if that's that person's only source of income, then you might want to steer them towards the benefit corporation, because putting them in the non-for-profit regulatory scheme is not going to be helpful for them. And if they decide, maybe I want to have my business be one thing and have a separate non-for-profit, great. You can start the process of having them create a separate non-for-profit, but keep in mind that much like with multiple incorporated entities in the corporate veil, you have to make sure that the assets of the non-for-profit and the for-profit corporation are as separate can be. All right. All right. Next, a serial entrepreneur. That's someone who goes company after company after company. They have this idea, they create a company. They have that idea, they create a company. They usually bring it up to where they get investors. They hire a new staff, and they move on to the next one. This is the type of person that B Corps are made for. Why? Because they are driven on the one idea. So if you have someone who's a serial entrepreneur who says, I have this great idea that's going to help people and it's going to make society better, you say, look, B Corp's the way to go for that. Okay. Now, if they're a serial entrepreneur and say, look, I'm just trying to get VCs to buy this and I don't really care about the environment, well, then B Corp's not right for them. That's okay. So another one, an active participant in the non-for-profit sector. All right. These are great. These are people who already go out into the non-for-profit sector and help out. Maybe they volunteer, maybe they're on a board, something like this, and they say, you know what, I want to be more involved in helping people. Now, once that comes into play, you have to ask that person whether it's really a non-for-profit or a for-profit kind of thing. Again, the B Corp is all about making money and helping people at the same time. The whole point of a non-for-profit is you're not really making money above your operations costs, which is why you're not paying taxes on anything. Okay. Next one, a passion for a particular cause. This is great. So I bet you that Comet Skateboards, I don't know the CEO of Comet Skateboards. I'd love to meet him or her, but I'm sure the CEO of Comet Skateboards went to someone and said, I love skateboarding. It's what I love to do, but I really want to help the environment. I wonder if there's a way I can put those two things together. Right? I mean, passion really is the benchmark of an entrepreneur anyway, but if you have someone who's passionate about helping people in addition to passionate about a particular sector or a particular activity, that might be a good candidate for a benefit corporation. All right. Finally, my partners and I want to. This happens all the time. It's very rare these days actually one person comes to me and says, I want to start a business. In fact, usually it's a group of people. Right, 2, 3, 5, what have you. And they come to me and they say a couple things. One, we want to improve the community. Great, we have this idea. It'll help our community, whether it's a town on Long Island or in someplace in Iowa, whatever. But we want to take a salary, right? We want to be able to make a living in improving the community. All right. Again, this is the two elements. You have profit and public benefit. I know it sounds like a broken record, but it's still true. And it's really important to have that hammered home, because if you have one but not the other, then the B Corp doesn't make any sense. If you just have for-profit, then have them be a for-profit corporation. You don't want them being held to a standard that they never want to meet. On the other hand, if all they want to do is help improve the community, and they don't want to make any money or bring in any profit, then great. The B Corp's not for them. They're for the non-for-profits. So you have those two elements, and then finally, we want to take this great idea of improving the community and attract investors towards it. All right, this is where the B Corp really shines, where you have people who are, as I said before, who are out there and they're trying to invest in causes that will help people and also make them some scratch at the same time. Great. Become a benefit corporation. Hold yourself out as one if you are so incorporated. And the investors will come. People who believe in your idea and who want to help people and make money at the same time. It's really kind of a win-win. So with that said, are there any questions?
We have a couple of questions actually.
Great.
Our online viewers.
Yeah. Why'd you let me get on like that?
You're just doing so well. We wanted to let you go. But the first one, who decides what is good for the environment? It's sort of a broad question, but a lot of people could make a claim that something is good for the environment based on their perspective. This person wants to know, who is the deciding body when it comes to making that determination?
That's a damn good question. And it goes back to what the material positive impact on things are, right? So with benefit corporations and with the non-for-profit sector as well, there's a lot of wiggle room out there, so long as the heart is in the right place. Okay, so if there's a scientific theory out there for a particular process that's going to help the environment, and some people say it will, and some people say it won't, that's okay. Find yourself one of those third-party companies who's going to say, hey, their intent is to help the environment, we're gonna do the certification. So it's not so much who is to say, but it's have the right intent and have the steps 1 to 2 to 3, like we want to do this, it's going to do this, and therefore it will help the environment. That will get you through at least at the outset. And look, if your one theory does prove out, great. If it doesn't, then you switch gears. Like any other corporation, we have a product that doesn't work, you switch it.
It's actually a great transition to another question. Do you ever find instances where companies who incorporate as a B Corp later decide they want to get out of that classification, and if so, why?
There hasn't been a lot of time for it, right? So, as I said before, Vermont was the first state to put benefit corporations out there, and that was in 2010. Hasn't been a lot of time. However, there is all the statutes have rules in place that predict what's going to happen. So let me give you a scenario. Well, let me give you two. Number one, new board of directors, they want us to change directions. Right? They're like, look, the public benefit thing is good, but it's not making us any money. What we really want to do is go off and make this other product, and that will make us some profit. And we really don't want to be bound by the public benefit thing, okay? Because if you're in a place like the state of New York where there can be an action for not pursuing the public benefit, right? Again, it's a double-edged sword. So that's one situation. The second situation is actually in the New York statute itself. If two companies merge and one of them is a B corporation, the new company is not a B corporation by its nature. And so the reason being that you have multiple philosophies coming together for a new company. So let's say, for example, you have XYZ Corp and ABC Corp, creative, right? And XYZ Corp is a benefit corporation. ABC Corp is a regular for-profit corporation, and they like the assets of XYZ Corp, and so they envelop them. They do a private equity kind of thing, and they merge. Now, the new 123 Corp, which is a merger of the two, is not a benefit corporation. The board has to choose. Is that
Right.
Any other questions?
Yeah, we actually have a couple more questions.
Go for it.
Okay. We talked a little bit about investors. At what stage do you suggest that a company who's classified themselves as a B Corp starts seeking these investors, or is it maybe a better strategy for them to hold on to a large portion of their equity until their theories are proven or their product is tested?
Excellent question. Really depends on the value driving aspect of the company. Okay? If it's a piece of intellectual property, if it's a trade secret, I'd wait. I'd wait a long time, in fact. I'd wait until you're well developed and you have a proven track record of keeping the secret. Because the last thing you want to do as a company is end up like Xerox with the mouse, or like almost anybody with Bill Gates back in the day. With full respect to Bill Gates, if your value driving aspect is a piece of intellectual property, hold on to it. If the value driving aspect is something else, like your board members' charisma or their personal network, then absolutely you can go and start getting investors right away, because there's nothing for them to steal.
This is a longer question. How do you build a business around this form of representation? You personally build a business when a lot of the companies or clients that might benefit from this structure don't know that it exists.
Well, that's part of why I'm doing this, right? Here's the thing. So I started my firm, actually a whole 6 months ago, I started my firm, and now I have 24 clients. I'm pretty happy about that. But I started my firm because I wanted to help business people, and I didn't want to charge by the hour because I was working at a large firm and I was being billed out in 6-minute increments. I'm sure a lot of viewers know that just drives you absolutely insane. And so I went out there to try to help business people do things in an ethical fashion. And so, the B corporations is one of the things that I do. I do a whole bunch of other things. I do mergers and acquisitions. I've even done a couple of estates. When you're in your own practice and you're a business lawyer, whole bunch of things you can do. I mean, I also do a lot of trademarks, although I'll never do patent because I was a classics major in college, and that's not helpful for patents. But as far as marketing yourself as as a B Corp lawyer or a socially conscious entrepreneur lawyer, you have to get yourself out there, go to the tech meetups, go to the social responsible entrepreneurship meetups, get yourself out there, educate people about the tools, the legal tools that they have at their disposal, including the benefit corporation.
That's it.
That's it. Well, thank you so much. I hope you enjoyed it.